And right
Wow.
now it's still a couple years, people waiting. So the delays on USCIS side are bigger and bigger. So that's my
The
impression.
reason why
Even with
I
Afghans, look, they had to interview everyone in 45 days, which they did a half. No, like almost everyone. And one person was left inside Zahidullah, and he was interviewed after 7 months since we filed. And long story short, everyone pending 9 months for response for decision after their interview. Could you imagine 9 months after interview, you don't know what's happened? So that's a big delay on USCIS side. Huge
Hmm.
delay.
of course, the reason why I asked that is because I know some colleagues in the marketing space that have they're here on the asylum pending case, and it's been pending for 7 years. They've never even gotten an interview, and
That's a
it's
Trump
because
era cases which got in backlog, and all they need to do just attack their asylum office like we did for Zahidullah, saying just move our interview anywhere in the country. We cannot wait anymore. And I think that was a great move John made, and it worked out. That's
very
the same
interesting. I've
status,
never heard that
USCIS
before.
interview status. Advise them just either email to the asylum office, literally the same letter we sent to Zahidullah, two sentences. Just give us anywhere in the country. We're ready for the
And do
interview.
we offer those services? Can we offer someone who's already handled their case to help expedite their case or follow
It's
up on
hard
it?
to promise. That's the reason, it's hard
Mm.
also to charge a person for that short letter and give them hopes. Maybe it's not going to work out. I think it's better for them just to be proactive themselves. Uh, am I right, John? Is that's
Oh, John, sorry, we don't hear you.
you're on mute? Sorry, some issue.
I don't think you want to dump your attorney just because USCIS has long asylum wait lines. I think that's the sort of thing that this community helps each other with, right? Give them hints and things like that. And that attorney should try that. Pretty easy fix, remedial fix.
Brilliant. Yeah, sounds great, John. Thank you.
You're welcome.
Well, John, welcome. We weren't expecting you today, but glad you're with us. We just kind of started, and Alex was just telling us about the excitement in his world getting a really tough Unite for Ukraine petition approved, and he's still celebrating that. And he was telling us about updates with the Afghan asylums and kind of what's going on in the world of asylum right now. So thanks for that, Alex. Appreciate that.
Thank you, Gabby. Thanks.
Alex, I
Cheers,
was
bud.
going to also ask, like, do you still see the same amount of volume with Afghan asylum cases? And I would think Ukrainian asylum cases are, of course.
No, of course no. Everyone is on TPS from those countries. They scratching their
Okay.
butt for many years, hoping that the green card's gonna fall, from the sky. Like many thousands of Afghans still, they got TPS eventually. They got work authorization, but it's
Mhm.
road to nowhere, right? It's just temporary status. They cannot leave the country. So, but they not rushing to apply from those countries for asylum. It's a big step. Russians right now applying. Russians have their place on fire, really, literally. And that's a very unique stuff that Russians after the war started getting paroled in at the border, which is very unique, where you can apply for work authorization the second day you entered for 1 year, and they get paroled in. Basically, you can even apply for asylum or leave the country without any punishment after a year, before the year. So very unique situation, which never seen before. That's from asylum side.
Right.
For Russian specific, like for Uzbekistan or Kyrgyzstan, hell no. They all go through the CFI, sit in detention for 9 months or so, still the same. But Russians specifically get paroled in, boom, no detention. Work authorization, enjoy.
So the argument is the Russians government is the aggressor, and that these are Russians that are have credible fear that if they stay in Russia, that they will be victims of their government's oppression, right? Whereas
Exactly.
Uzbekistan is
Because
different.
of the forced conscription. Forced
Right.
conscription,
Yeah,
that's
yeah.
one thing that everyone
Yeah.
claims. The second thing, opposition to Putin. And the third thing, like standard stuff, like religion.
Yeah.
And technically by country, Russians have green light, just come in, enter, and not many Russians know about it, but that's a fact. Like for the last 4 months, I think they start giving everyone paroled in.
Oh, that's fantastic. That's great news, Alex. Great thing.
Mm.
That sort of segues to something Yesh has been working on with the U visa. Yes, can you tell us a little bit about your week? And you're looking at the U visa, why it's an option. We're just putting that into Visas.AI now. and how you might use it for a couple of members of a family.
Hey, yeah. So what we had was a case where the husband came in on a visa waiver from Chile, and his spouse and child came in on a B1, B2. They overstayed for, I think, 5 years. And he was picked up by law enforcement and then handed over to ICE. So ICE had basically, since he came in on a visa waiver, he doesn't get the same rights or opportunities as if you had actually come in on a B1, B2 and just overstayed. And so he was automatically put into deportation proceedings. He was given 30 days to kind of leave on his own. But when we looked at his case and seeing if he would be eligible for either a U or an asylum, when we screened him for a U, it seems like he might have a strong chance for a U, him and his wife separately. And what's great about the U visa is courts or the judges will offer or waive your stay or your overstay very liberally in that case. So,
But
so
there's
that
a tough
helps.
part of it, right?
I'm sorry?
There's a standard. The tough one is getting the police force to sign up on it, right?
Yeah. So U visa, as you might have known, is for victims of crime. So if you had any crime committed against you, if you were a felonious mugging, or if you were shot at, if you were a victim of rape, if you were a victim of employment, like if someone made you work but didn't pay you, things like that, you'd be eligible for the U if you are willing to cooperate with the law enforcement in catching a perpetrator. But the most difficult part of that is getting your getting law enforcement to sign off on it, saying that you, yes, are helping the victim is helping the law enforcement officials catch whoever committed the crime. But if you get that, you're basically getting an EAD card for 4 years, and the wait time for adjudication on the use is sometimes 10 years at this point, because there's only there's a limit on how many U visas are issued every year.
So that's an excellent strategy. Here, right?
Yeah. So, it's something that in the meantime, they can see if they qualify for any alternative immigration relief while they're waiting, but they're also having the ability to work while they're waiting for their case to be reviewed. And so if you have nothing else, and if you can screen them for a U if they're eligible, and you can get law enforcement to sign off saying, yes, this guy has a credible reason, or there's a crime that was committed against him, and yes, he's helping us, he's cooperating with law enforcement to catch them, then that's a great strategy for them to be able to stay here on.
Right. That's awesome. Wonder. Why don't you talk a little bit about without using their names, the basis is
You're really
of the two family members that might be able to get the U.
Okay. Sorry. There's an echo, Yesh, with your. So if someone else is talking, please mute. I think you got it covered now. Go ahead, John.
Oh,
I was asking if
sorry.
Yesh would go into the two types of scenarios, crimes that she's looking at for this husband and wife situation.
Yeah. So one was the one that we were talking about, where so the husband, he I guess was going to a farmer's market one day, and he was mugged. So we could kind of put it under felonious assault because the guy had.
Well, let me step in for a second. Yes. Why don't we do this by using the U Visa strategy tab? I just opened one up under Betsy Ross's deal called U Test. Can you take us through the U strategy? Do you know how to do that? And share the screen. Gabby, could you share the screen maybe? If that's tough for Yesh.
I think if Gabby shares the screen, I can kind of direct her on how to go about it.
Okay.
Oh, thank you. I definitely will look at it then for sure.
Okay, so click strategy
All right, so I'm
session.
in the
Click strategy session.
I think if you hit UV, oh, there we go. So I basically, if you can, the petitioner name, all of that. Let's see, I'm trying
Make
to
a dummy version of this.
Make a dummy
version of this. So we can look at how OV to the right helps, and you can just make up a fake name for one of the people you're talking about here. And if you go through this, this will help us with the elements of what's necessary for you.
Okay. So what's the beneficiary?
So these are all.
what's the beneficiary?
Oh, sorry.
Go ahead. Yes. Go ahead. Yes.
Oh no, I apologize. So the victim or the crimes that qualify for a U visa, I've listed all of them in there. You could have been blackmailed. So you can walk them through their situations. You can ask them, if they've ever had any issues against them, like being robbed at gunpoint, or if they were trafficked. A lot of times we have victims that there's employment-based crimes where they're promised or they're worked, but they're not given the salaries, or the employers tell them come on in and they take away their documents, and then they threaten them with immigration consequences. And so blackmail and all of those can be qualifying criminal activity. I don't know if we want to. Do you want to pick one? I haven't. I'm gonna try to see if I can build out a note for each type of.
Just pick one for. Let's just pick one for. Let's use an example, right? So you can use one of the examples of the people you've actually talked to. You can change it a little bit. We don't want to use names, but I think as opposed to going through how every crime would meet this, just pick one to show somebody an example of what you would do using this system.
Oh, sounds perfect. Let's do go down and see felonious assault. That would be one. Like your case, Alex, this would probably be the one that would fall under. Or you can, and then so then the next question is, have they reported it to the law enforcement? Now, it's not always necessary that they do it right then. You could always, even after a couple of years, a lot of the victims, they don't tend to report it to law enforcement because they're worried about getting in trouble with immigration officials if they come forward and shine some light on themselves. But this is the reason why we have a U visa, is to protect these kind of individuals that are, victims of a crime, but they're not here legally, or they're undocumented, but we want to prevent that crime from happening. Let's see. You can also petition. I know where it says, are you the victim of a crime? You can hit yes or no. You can also petition for somebody that, if somebody had killed, or if somebody had murdered a family member and you're an immediate family member, you can also petition for yourself. And so this is another, you yourself don't have to be the victim. You can be an indirect victim for this U visa. That's something that not many people are aware of. And so that could also be a relief for somebody that, it's a relief that can be offered for somebody if they were an immediate family member. If their immediate family member was a victim of a crime. Let's see.
So for
being
reported to police or law enforcement, should we say yes or no?
So if you say no, that's completely fine. It's just you have to just take the steps. We would coach them on what the next steps would be. If you hit yes, we would just have to get another form that law enforcement has to fill out and submit along with the application.
Is that what
in
this
support
form was?
Is that what this form was?
So the supplement B, whenever you click, was the crime reported to the police or law enforcement? Is this the form that you would submit with that?
And just a small comment, guys. Sorry, nobody asked me, but I worked at some point with, Latino-based client company who in San Diego who filed a lot of U visas there, and I've seen RFEs requesting for police reports still after 3-4 years it was filed, and actually accepted. So there's a possibility to file without police endorsement in the very beginning. I didn't do that myself, but I know it's possible because we had RFE after 3-4 years asking for police report, and the clients didn't know when it's happened and what hotel they got robbed and what police station they reported it. They still struggled, but they accepted your visa at some point. I know that for sure.
Yeah. It's not always, that's why, it's not always a requirement that you report it to the police. Now, if you do report it to the police, or law enforcement, whatever law enforcement you report it to, they have to, fill in that form 918 supplement B. And that kind of just tells it states what the report was, the incident, and that these people or the individuals were helpful in their investigation. But yes, Alex is right. You don't always have to do it. There's other ways. If we, they don't always require it if you can show other proof about what happened. And as Alex said, they do accept a U visa without it, even if it's been 3 or 4 years since the incident happened and you haven't filed a report.
Thanks, Yesh. All right, so that's number 5. So let's move on to number 6. Are you the
I have a question on that. Sorry, can you file a police report after the fact?
Yeah.
So even if so when they asked it 3 or 4 years ago, they could go in and file a police report that this happened. Now, will the police accept it? Will they take a report at a later date, or if they do, will USCIS accept it? What are the thoughts on that?
Depends.
Depends,
but you should always try,
Yeah.
Depends.
Yeah, exactly. It depends on the law enforcement officials as well. And, if you can, we tend to urge the clients to put in as much detail, but after 3 or 4 years, depending on how traumatic the crime was, they may not remember all of the details. And that kind of, at that point, you're putting the ball in law enforcement's court saying, hey, if they're willing to accept it or not, if they're willing to sign off on it. But we sometimes, if we're still waiting on law enforcement to sign off on it, like Alex said, we would just go ahead and file the application without it. And since the wait time is so long for a U visa, you'll get an RFE later on. At that point, then we can either try to supplement it with other documentation if possible, or we can follow up with law enforcement to see if they can sign off on it at that point.
Thanks, Yesh.
Thanks, Yesh.
So let's move on to are you the victim of the crime? So this is where it will take you through. If you're not, what's your relationship? So, what step after that?
If you're not the victim of a crime, then you have to state your relationship to the victim, right? So, sometimes if you are the parent or if you're a sibling of somebody that was murdered, or if you were, those are the if I believe you could, those were the ones that immediate family members, children, and siblings, like direct siblings, unmarried siblings under the age of 21, correct me if I'm wrong, are the ones that can qualify as an indirect victim. And so, you don't have to be the victim that's filing, you can also be an indirect victim, and that's kind of that's an advantage of the U as well. Let's see. And at one point you're going to have to say if this crime was, has affected you physically or emotionally, or psychologically. A lot of the times when we had done U visas, we would get our victims evaluated, documentation, any documentation that can prove that that incident had affected our physical mental health of the victim would help. So doctor's records, or if there was hospitalization, or if there's any photos of, of the bruises or hurt or harm that was caused by the crime, that really does help with the case. And the last thing that I want to walk you through is 9, which is do you qualify for a waiver? This is where this is the biggest advantage of the U visa, is the overstay waivers are granted liberally, very liberally by the courts. And so when in our current case, our victim had come in on a visa waiver. He had overstayed, but if he files the case, when we file the case, we're going to request a visa. We're going to request a waiver for his undocumented overstay. And so that, even if you came in on a visa waiver where you give up so many rights, or it's still granted liberally, and so that will excuse his overstaying for 5 years. So this is a great opportunity. I mean, this is one of the advantages of the U visa, because I don't believe any other visa would grant a waiver so liberally as the courts do for this. Sorry, if you guys have any questions, please just ask.
Thanks, Yesh. Yeah, this is very interesting. I haven't actually been informed very much about the U visa or learned very much. So it's really interesting to see that you can apply for this even if you are not the victim of the crime yourself. That's definitely something that I learned today. Over to you, Ben.
Yes, the fact that they're more liberal in granting the waivers, and that's because the nature of it, right? These are victims. I mean, is that probably a fair statement?
Is the labor cert, right? And so
That's
the
right,
labor cert is the third thing to do in the initiation of that green card process, after the prevailing wage, after the recruitment, which includes the quiet period. So if that prevailing wage period, which used to be a matter of weeks, which is now 5 or 6 months, means that at 5 or 6 months, and if you were as fast as you could possibly do the recruitment, which is 2 months, so let's give it 3, that's 9 months. So that's 9 months in front of the year. So if you do the math, that is all of the 6th year, and in 9 months of the 5th year. So that leaves it at 3 months into the 5th year, right? You'd have to initiate that, and you still might get delayed. If the attorney slows down between any of those processes and isn't right on top of it, and you miss that filing of the labor certification, then you will have to leave for 1 year on your H-1B and reapply. Right, as opposed to continuing it on. Now, if you get the I-140 approved in that process, that for the H-1B means that they can extend their H-1B in 3-year increments. Between that time of the filing of the labor cert and the approval of the I-140, they can just extend it in 1-year increments.
Right.
The other thing to remember in that is that with an approved I-140 on an H-1B, then that is the limited exception where the H-4 can obtain an employment authorization document, meaning their spouse can work doing anything. So these are really interesting things that perm attorneys need to know when they're dealing with certain visas. And that approval of the I-140 is also important because you keep that priority date. in the priority date issues on the filing of the labor cert, not the I-140. So what happens a lot when we do high volume H-1Bs is that these are folks, because their priority dates might be 12 or 15 years, that they may move, they're going to move jobs lots of different times within that period of time. And then in order to get the new job, because they're a hot commodity, they'll demand and require that a green card gets filed for them. They have to start the whole labor certification process over again, because that is tied to the employer and the job, not to them, even though they had an approved I-140. So they'll do it because they can use that previous priority date. Right. And
That's
then,
right.
and then
That's right.
the owner of the new company needs to look at that priority date when they get somebody, because then they can start that process. And if that priority date is current, which it's not at the initial filing, but if it is, if you're the second or third filer, then they can file the adjustment of status contemporaneously or concurrently with the I-140, right?
That's correct.
Yeah. So it's, there's a lot of things to know.
Yeah, those are really good points. And you know, when you were talking, John, I thought of something an Indian client told me about 15 years ago. He goes, Ben, do you realize that my priority date is as important to me as my birth date? Think about it, right? I mean, that is my whole future to be in the US. And then, guys, I love the real world aspect of this, right? Okay, well, you're out of time. You're going to have to leave the country for a year, reset. I mean, is that job really going to be waiting for you in a year from now when the company is swamped and they're doing a million things? Is it really realistic to expect a company, a US company, who loves you, right? That's why they're doing all of this. They're sponsoring you for permanent residency, paying for all the fees and all that. But they have their limitations too. Is it really rational to think that the job is going to be there for you in a year when you come back? So there's all of these, you might be gone for good. You see what I mean? So there's just all these real world implications that, of course, you know, U.S. Department of Labor and U.S. Immigration doesn't really consider. You know, that's not our problem. That's your problem. You know.
Cool.
Joy
has her hand up.
Yeah, love to hear your input, Joy.
So I guess my input is actually from the employer side of that equation. So Ben, my job is reviewing whether or not we're going to process those types of applications for the company that I work for. And 9 times out of 10, we will not do a perm application. They're just not viable considering all of the restrictions that you have to consider. You're not allowed to use any of the skill sets that the individual gained while working for the US company, the amount of time that it takes, the recruiting campaign that has to be done. You know, unless you hire somebody who's exceptional to begin with and they have tons of experience and you're doing the perm application immediately, then from a company perspective, it's not worth the investment. No. I can tell you, in the 9 years that I've been working for this company, I have done a total of 3 perm applications, and each one of those perms were in highly specialized areas of research and development.
Mm-hmm. A real special need. I get you. And you know, I do think about that, right? And John, please help me tactfully say this, right? I'm in my 27th year of doing this. You know, when these time frames from government gets longer and longer, you kind of can't help but wonder, is it kind of on purpose? John, please help me. You know, where are they dragging it out on purpose, right? There's politics involved, there's other things involved, and I'm not well-spoken enough to say it right. Okay, I'm going to say something offensive or something, but you know what I mean. It's like, hey, I think they're dragging it out.
Well, what you're getting at is a weird conflict that exists in immigration, right? You have one attorney that represents 2 different parties that may have opposing ideologies regarding any number of specific issues. I represented a gentleman that was at Microsoft, and he was in Fuse Labs. That's their think tank, right? This guy was brilliant. Before going to Microsoft, he had launched a social media product 1 year before the invention of Facebook. There was a thing called Friendster that was somewhat similar to it. And then he had, and his investors pulled back on him. Then he avoided a VoIP, a voice over internet protocol. That's the kind of calling system that Zoom's on and all the other ones, right? And he did that years before there was any of that, and China made it illegal. So he comes to America on an H-1B for Microsoft. While he's at Microsoft, they have a contest. This is how they find the really great ideas they have. It's called a Bill Gates contest, and all the different people at Microsoft could put in an idea. There were 3,000 ideas put in. His was picked. And Microsoft actually did a social media platform for a while called SOCL, which was based on his knowledge. Microsoft sponsored him for an EB3 green card. He's Chinese. His weight was, close to 20 years at the time. He came to me. We were able to get him a green card under the EB1 category in 4 months. It's the fastest one I ever did. They did it, including an RFE, 4 months long, and they gave him a green card. In that next year, he launched 4 companies. Microsoft was slow playing him. He could have been an EB2, which at that time, this was some time ago, was a significantly faster deal. But they wanted to keep him, right? And they knew that he would leave. Right. So there's a couple things going on. So Joy's completely right from the employer's perspective. This is really expensive. And if we put all these efforts into a green card, they're gone. So why should we do it? We don't have an obligation to do that. But the employers want them to. So what we have is the green card processing is a chit. It's a negotiable item. It is something that is happening. We're seeing it with some of our high volume H-1B clients on how they can get and keep their folks, right? But the minute they have the green cards, they can leave. So what do you do on that? Do you give them an equity piece? I don't know. I mean, these are interesting questions, but it strikes at the heart of the conflict that attorneys are in. If the employer wants them to go slow, that's who's writing your check, right? But the employee wants you to go fast, and that's the beneficiary. But they're both your clients, and that's an interesting thing. And I've yet to really see 2 different counsel representing any one. The 2 different people in any visa. So this conflict of interest is inherent in our business.
Our practice, that's right. And John is exactly right, Joy. Remember, as immigration attorneys, there's dual representation, right? I'm representing both the employer and the employee, and the employer, hey, you don't have to be in such a rush, man. Because again, the longer it takes, the longer he's with us, right? The longer we're locked into that salary, the longer he won't leave us. He knows if he leaves during the perm, the new company would have to H-1B transfer him first and then start the perm over again. So, and then, I get off the call with the employer, the foreign national. Can you please make it go faster? I just had a phone call with your employer. So there is that conflict. John is exactly right. It's a balance, and it's hard to balance sometimes.
Yep. I think the way Joy's company sounds like they do it, that they're very finicky and picky when they do it, and I'm sure they go through the process quickly once they make that decision. But so the key there is to and Joy, go ahead. I'm sorry.
I was going to say the key there is actually having an immigration attorney in-house that can evaluate the cases before they even go to the attorney.
Right.
Yeah, because I don't process the cases. I have all of the internal discussions. I lay out the process for the business. We make decisions, and then we hand it over to somebody to actually facilitate the entire process for us.
But I get you. I mean, you're also looking at the time, right? One factor you have to look at is how much time does this person have in the U.S. He could be on his 3rd H-1B when he joins your company. He's in his 5th year, and 5 months. He's got 7 months left, and he could be brilliant. He's the most brilliant whatever you've ever seen in your life, but you're going, oh, there's just not enough time. That's another
Yeah.
factor. And I've seen companies start cases that are like, oh, we forgot he's on his 4.5 year of H-1B, 6-year max. These are all the factors that that John kind of brought up, right? Really, right. If you're looking at a 9-month time of frame for just a prevailing wage request, it would have to be, John, 4 years and 3 months, right? That would be like the maximum someone could be an H-1B to get the 5th year, right? To get to file the
Yeah,
perm.
you really need to. You really need
There's
to
a lot of
start.
math involved, guys, which I
Well,
don't like. You got to go backwards
well,
and
here's.
count the math.
I think, yeah, you don't want to go backwards, Ben. It's really good. So here's the takeaway. Here's the nugget. If you want to do a green card for somebody, start it immediately after you file their second H-1B.
Yeah.
That's what you have to do. And if you're onboarding somebody from another company and they haven't filed an I-140, that has to be in the analysis, because Joy deals with this all the time when she's looking at for her company. How much time do they have left on their H? So how much time can they work for us? Right. So in the hiring process, that needs to be a question. But, we're not going to be able to solve this question for potential employers. This is for immigration attorneys. We sometimes don't have the question asked of us in time. Joy, you're raising your hand again. What's your input?
Yeah, actually, I was going to say right before you did, I do look at this. I mean, talent acquisitions comes to me quite frequently, and they'll say, oh, this person doesn't require, the cap for the H-1B. Can we hire them? And my first question is, how long have they been in the U.S. on an H-1 already?
Right.
And that is a critical decision factor in whether or not we're actually going to hire that individual. Because if they're on their second one, I tell the business, you've got them for approximately, 18 to 36 months, and that's it. So if you're not going to start the green card application immediately, it's not going to happen. And then you have to take everything else into consideration on, is it even a viable application to begin with? Are there going to be other qualified U.S. nationals that can fill that role? So yeah, we consider every aspect of that.
It's awesome.
It's so great to have the employer's perspective and
Yeah.
put on this, because often as on the law firm side of us, we're kind of just wondering where people are at in your shoes. So it's really awesome that we have your side and your perspective with your background as an immigration attorney as well. It's awesome that you can see both sides of that.
Well, guys, I don't know if you guys realized it, but this was a fantastic CoLab. A lot of interesting visas covered, use, Vs, Asylum, Perm, applications to the H-1B, hiring implications. This was a hell of a conversation that we just had. And it was just a really good conversation between a lot of people with different perspectives and different knowledge from different, that came into the same profession from different places.
Yeah, and to piggyback on this, I know we're still currently recording, but for next week's CoLab, I love this kind of structure. I think when we kind of go into the first half being like a lecture, we don't have as much space for this open collaboration. So I'd love to continue with this energy.
Yeah.
I think something that would be helpful is, throughout the week, as you're coming across interesting things that you would love to bring to the group, just jot them down. That way, we can continue to have these vibrant discussions. This is awesome.
It was very organic, Gabby, that we got to have Yesh go through a U visa using the platform. I think what we could do is have people that have elements in how they use the platform to do it. I think that brings something to the table besides just a bunch of talking heads. We're showing this dynamic, ever-growing platform. The U visa is one of our more recent visas to add into our ever-growing database of visas. The reason that is that we invented this from a business visa perspective first, and now that we're onboarding more people with different visa interests and types, we're growing, and we're growing in a very natural way. So that was really cool. So I think in we can throw some ideas to the group, and beforehand, folks can come back and say, "Hey, I'd like to show you my thinking on the visa," and then we'll just use the demo site for Betsy Ross to do that on.
Great. So we're coming up on the end of our call now. We've got about 4 minutes left. I'd love if anybody has any parting thoughts to share, and if you guys have any ideas on what we kind of want to spotlight next week, that's please, it's open for that as well.
Or questions that you want someone to answer.
That's great. Yeah, I have a quick question, John, and this is obviously it might sound interesting to ask this question, but when it comes to the H-1B, one of the things that I've been still trying to understand is, so you go and get a college degree and you get a really good job and you do all what you have to do, and you're still in a lottery. So basically, how does that specifically work, and what are the chances of someone in the U.S. making the lottery in your opinion?
Oh, Pierre, that's the question of the day right now, right? So we just finished our lottery registration. That went from March 1st to March 17th. They'll release the results probably the last day of March, because the earliest you can apply for a visa is 6 months. So April 1st is 6 months before October 1st, which is the fiscal year. And that's what this is, a lottery for visas available in the fiscal year that's coming up. It starts October 1st. So we had almost 500,000 registrations last year. That was a 17% chance for the 65,000 bachelors, which is the regular cap, and the additional 20,000 for master's or PhD, what we call advanced degrees from U.S. institutions. So it's 85,000 total, but 20 go to these folks. So 17% last year. There are people thinking it'll be higher. A big issue is double registrations or duplicate registrations, because individuals that they're going to as many companies as they can to up their chances from 17%, but they're punishing companies that duplicate those. Now it's a no-brainer if you're one company and you duplicate it, but USCIS, one of the reasons I'm up right now where I'm at to deal with clients is on issues of related companies or not related companies that USCIS is deeming are related. And they're claiming that if somebody that there are people in different companies that are filing these things, that they're saying they're colluding to commit fraud against the U.S. government, which is a massive accusation, right? I mean, fraud is nothing to mess with. That's how you go to jail. That's how you can get deported. There's all sorts of horrible things that come with fraud. And so here, I actually answered an RFE saying that they should really be ashamed of themselves. These are people that try to build cultures of compliance. They live within the law. They've not been in any trouble. And now you're throwing around words like fraud that can really wreck their lives and really impacts them negatively, right? I shamed them in an RFE, really calling them out to see if they want to litigate this. Every other fraud case that we're seeing is when someone, they traffic people, like we talked about, either these U crimes, right? Where they fake documents, where they've completely, conspired to commit these crimes to really hurt people. What they're trying to say fraud is two different companies that may have some connection, both applied for an H-1B in a registration for a lottery. Where's the fire? Where's the crime? You want to get a U.S. attorney to defend that? I will definitely be on the other side of that case. And so that's really interesting right now. And I think that's going to be a really hot button topic for companies going into this year's H-1B season. So Pierre, couldn't have said a better one. We could talk for an hour on that subject, but what a great parting question. Thank you.
All right, guys. Well, we are at 12 o'clock. So thank you all for amazing, organic, wonderful collab. It was so wonderful to hear from all of you and all your different perspectives. With that, I hope everyone has a wonderful weekend, and we will see you all next week.
Great emceeing, Gabby.
Bye, Alex. Bye,
Bye.
Joy, Gabby. Bye,
everyone.
Ben. Bye, John. Bye, Alex. Bye, Yash.
Thanks, everyone. Thank you.
Thanks, everyone.